apply to a lease. So yes, we didn't.
I think the main word there might be required.
Well, the key word might be required, and yet those are required laws for if it's not a lease. So I'm just saying that I'm not so sure this necessarily slams our hand in the car door. I didn't say it didn't, but I'm not sure that it was like it was 48 hours ago.
I do remain concerned, though, that this signing this statement may very well be used against us later on. And the Board of Education, there's different rules of evidence, as we've heard from counsel, and that the use of this particular document, if we were to sign it, may not be used in certain court cases in the future, but that doesn't necessarily govern what might happen in another setting, the Board of Education. And I'm just concerned that any admission on our part that there was a violation here when we make the case that there wasn't, may be used as cause for revocation of the charter.
I think we are in a perfect catch-22, and it couldn't be better stated than it is. I think it's very clear, as I understand it from the research that I've done, that if we don't sign it, then our charter will most likely be revoked because we will have not completed number 1 on Commissioner Chester's list, which is to come to agreement with the Attorney General's office. And we know this is the best agreement we can get. Council has worked very hard on it, I have to say, having little word changes and negotiating the thing for quite some time now, up to the ultimate deadline of today. So I know that we're not going to get another copy. I know this is what it is. I think that how I understand this is that this is an agreement to disagree in some fashion. That the Attorney General does not see things the way we do. That we believe and understand through our counsel and that we didn't violate any open bidding laws. And they disagree with that. We don't quite understand why they disagree, but they're very clear that they disagree. So I sort of see this as our only hope going forward. That if we don't sign, I don't see any other option that will happen. If we do sign, we have completed all the commissioners' requests. And I want to say I feel like we've completed them very well. And I can only hope, since that's what the Department of Ed set up to us, they didn't say anything about us admitting fault or not. They just said you have to come to an agreement. And this is an agreement. So I would be hard-pressed to understand why the Department of Ed would revoke our charter after we had met every single requirement that they put forward. Whether I agree with this or not, I'm sort of saying, to me, at some level, is not part of my issue. If my goal is to keep the charter open, and after, certainly when I hear from parents what the school has done for their kids, it certainly is a motivator for me.
I feel the same way. I do think it's a catch-22 situation. I think it's very heartening to me that our lawyer was able to get the statement changed to, instead of failed to comply with the competitive bidding process, that we did not follow the required competitive process as it now stands. I think that's a very big thing, because it's true, actually, literally, that we did not follow the competitive bidding process, and there are reasons why we didn't. Our reasons are referred to, which are also referred to in this document, the letters that are in the record. The letters are from our lawyer. Any really fair person who wanted to investigate this would have to look at our lawyer's letters and see very clearly that we had a different legal interpretation of what the issues were and what the contexts were. I'm very heartened by the language, again, that we were able to get in this document, that this agreement I forget what the exact phrase is, but cannot be used in further legal proceedings against us, because a number of us really worried that admitting this would lay us open to further litigation and some sort of legal trap at the end of the tunnel. And I think that language means a lot and has done a lot for me in thinking about whether or not to sign that. It's clear from the document, it should be clear to the Attorney General's office that our commitment to the spirit of what people mean by competitive bidding and open and fair proceedings is very, very strong. And all the other steps we've taken, I think, should indicate to the Attorney General that we're very serious about complying with the law and really are determined to do that. I think we should sign the statement, and I think it's actually an obligation of the Board of Trustees to sign this statement, because our first commitment is to the continued existence of this school.
I think the other thing I want to add too is that we have been caught, obviously, in tremendous political battle for a very long time. I think that I could probably say all of us on the board would like to move forward to the job of governing the school and not dealing with the Attorney General, the Inspector General, the Board of Education, in the negative light that we have. And I think by signing the document, I'm hoping that what it says to the Attorney General's office is we'd like to move on. We'd like to put this behind us. We agree to abide by the rules that we've laid out in this document as we move forward. We're even agreeing to publicly bidding things that are, as I understand it, below the threshold for anybody else that we know. So we are going above and beyond, I would say. And I hope that's a signal to the Attorney General's office that we want to have a good relationship with the Attorney General's office. We want to move forward, and we really want to get to the job of governing the school. That's what we are meant to do. And a lot of our time is taken up with these other issues, and it's frustrating on many of us.
I'm going to just complete my signing statement to say the more I look at the language, I don't see that it says that we violated laws. It also says the parties now wish to resolve fully and finally any and all claims or causes of action that may be brought by the Attorney General under the competitive bidding laws. And meaning, it's not saying you're definitively going to get sued by this stuff. It's still, there's no definitive statement that this applies to you. And it's not saying that these will be bought, that these actions have been brought, that I'm not so sure that they're not saying that, admitting that it hasn't been proven yet in here, okay? And that we are resolving fully any claims or causes that may be brought. So now that's not an issue anymore, if we sign it. Is it, according to this language? Fully resolve and finally any and all claims and causes of action may be brought by the AG under the competitive bidding laws.
See, Gordon, I think it resolves it for the Attorney General's office and for legal, other legal entities, probably the Inspector General's office.
Mm-hmm.
Yes.
But my concern is that it doesn't protect us, it doesn't govern what the Board of Education might do with this.
No, it doesn't. But it certainly...
We can't have
If
that guarantee.
There's no guarantee.
They could say, okay, they broke the law, that's malfeasance, that's ground for revoking the charter. But that's not true. Where does it say they violated the law? They said that we acknowledge, it first says that we discussed it with counsel so that we considered a choice. Then we mean, take it right through. They exchanged letters, and so all the arguments are brought, and then they're saying that we agree that we didn't follow that. And as I still say, Joe might say because they don't apply to a lease. And now everything is resolved if they agree to this. But where did we say we violated the law?
I think that, you know,
We violated the bidding practice.
the thing that worries me about it, I guess, and I'm just not sure why, with all this back and forth communication, was it so impossible to resolve this issue. That essentially, from this documentation, this is the September 16th letter, and I'm going to take just a second here, and I want to read this letter in its entirety. So that
Say who the letter's from.
this is the letter from our counsel, Colin Zick of Foley Hoag, to the Assistant Attorney General, Judd Nozel. It says, Dear Assistant Attorney General Nozel, it was on September 16th in response to their letter of the 15th. After the Gloucester Community Arts Charter School, GCACS, I wish to acknowledge receipt of your letter of September 15, 2010, regarding certain public designer selection and construction issues. As you know from our prior discussions, GCACS disagrees with your office's conclusions about the actions of GCACS as they relate to the school facility located at 2 Blackburn Drive in Gloucester. GCACS does not dispute that the Brazzi case now controls public construction projects. At the time of the lease for 2 Blackburn Drive was entered into, however, Brazzi had not been decided. Indeed, Chief Justice Marshall in the oral arguments in the Brazzi case decided on May 10, 2010, well after the contracts in question related to Blackburn Drive were agreed to, stated that the public construction statute as written doesn't cover a lease, and that extension of the statute to leases would be an extension by implication.